Hello, hello, hello. Wait, what? What's that, Penny? Ziggy touched you in your sleep and now you're pregnant with twins? Oh, shit. What are we going to do? Should file a paternity case. What do you think would happen?
Nothing. Nothing would happen.
You lied?
Who
You
lied?
lied?
Did you commit perjury?
Penny. She didn't think I'm mad at her. Good girl. Good girl. Good girl. All right, everybody say hi to Penny. She's all
Hi, Penny.
fluffed and cute and groomed.
With the bandana and everything.
I know. And she's kept it on for like a whole week. It's amazing. Y'all, we have a ruling.
We do.
We do. And I've watched it already and probably watched it twice on the other channels, but I haven't been able to see it start to finish. And I need to go what's going on here. I've had kind of a chaotic morning.
Do you have it or do you need me to bring it up?
I've got it, but I have to show everybody this first. So, new from the Meg's merch store. Pretend like we're doing an unboxing and I'm opening a box in the mail. Are you ready? Don't judge me. Don't judge me.
How many different judges are on that?
All the good ones. Don't judge me. I know. I have issues, but I love it. I get to sleep with all my judges in my big cozy sweatshirt. I bought it like 3 sizes too big. Well, whatever. A quiver in anticipation.
Oh my.
So despite just a little minor perjury, we still made it to a ruling. And Judge Mata entered her ruling? Submitted her ruling?
Yeah, it's final.
Filed it?
There's no talking about it for 3 weeks. Yeah, it's done.
Yeah, you know me. You get around. Gotta keep it interesting. So, every morning, Jingris has posted very early about his access to the filing. So, I usually check his Twitter first thing in the morning to see if there was a filing. And I didn't see anything this morning, but then all of a sudden, everybody's live and there's everything. So I was kind of surprised. But I want you to know that I did post on his page, his Twitter page, and offer him a chance to come on and give his side of the story.
Yeah, he's certainly not going to want to do that from his cruise, even though he's filing his appeal on his cruise.
Well, he's been posting every day, ranting about everything. And I thought people can be misunderstood in text. Lots of times your intention and your sarcasm, things like that don't come through correctly in text. So I thought, okay, maybe hearing it verbally would make me feel differently. I would like to hear that. As long as it's the truth. The whole truth and nothing but the truth, so help you God. We'll see. So, here we goes. Is this big enough?
Yeah, it's good.
Okay. Have you read through this whole thing already? Twice?
Yes.
Anything? Okay.
So the first 13 pages are the facts as Judge Mata sees them, as presented through the evidence and through the testimony.
So is there anything... Do you guys want me to read the first 13 pages of...
stuff?
Yeah. Were you planning on doing it?
Me? I was not, because I imagine that... Because I know that Meg did it, and Dave has gone through it. So I didn't know if other people just wanted my voice over reading it or not. So I was just planning on summarizing everything. I mean, if you followed the case, you largely know everything that she's saying. It's just a matter
Yeah.
of finally getting the judge's words to say these things did happen, or these things are, or the petitioner said these things is interesting, because now it's a matter of record and judgment. So these things can be used to help further the other cases, whether it be the orders of protection, and if Clayton still has the opportunity to do the appeal on his order of protection, then you can take this document in and be like, hey, this judge found all of these things.
Once they're listed here, they're presumed to be factual.
Yeah.
And somebody has to actually disprove them at this point in time.
Although the interesting
Can you hear that
thing-
noise in my background?
Yeah, I hear a little bit of a tin. But one of the interesting things is, in the very beginning of these facts, it does state that that sexual intercourse may have occurred, but it's interesting, and I'll have to see if I can find out where in which page it is.
Okay, so this says she filed the amended motion. He filed the motion. They had the OOP the same day. These are kind of all over the place. Little to no fetal DNA was found. Then they filed for mediation. The parties appeared before Commissioner Galketis.
Oh, okay.
And this
so it's on page 4. It's basically
Clayton's.
the notes of what Judge Mata was taking as the different witnesses were on the stand.
Oh, is that what it was? I thought it was from the filings. Okay.
Yeah, because these are the summary of the events per the docket. Then it goes into facts from the witnesses.
Galketis was Clayton's OOP or IAH, whatever. They have so many weird names for it. And then down here, Duty was
Duty
first.
was the OOP. Galketis was the IAH.
Which, shouldn't it be the same thing?
You would think that they're the same, but they're differentiated in some manner, and I haven't gotten to that point yet.
I can't see page numbers. Is this the right page or the next one?
Page numbers is at the very bottom, in between the left and right arrows.
Yeah, it like gets okay. There's page 1. So you want me to go to page 4?
No, in the window, not on the page. There's
Oh, I can't see it.
Oh,
Okay, I see.
yeah, that's 2, 3.
3, 4. I have my little. You're sharing your screen right over top of it.
Hide it. I always hide it.
Oh, you can hide it. There's a button that says hide. Imagine that.
Yeah, so if you scroll up just a little bit to the bottom of the third page, it'll say, like, statement of facts or... Oops.
What? Findings of fact. Okay. Who puts their head? Okay. We won't talk about court grammar.
So these are basically the notes that she was taking while Laura was on the stand. And then...
So the petitioner contacted the respondent through LinkedIn. So that was her finding, because there was, in some of the testimony somewhere, they were saying that they contacted him through the office.
Someone said they called the office and then he was referred internally, but that's obviously not the case, because they were... Clayton had said multiple times that she found me on LinkedIn. So...
Yeah. Big Tiff in the house.
Hey,
Everybody
Tiff.
say hi, Big Tiff.
Hello.
Okay. Petitioner has a podcast. Between May 18th and 20th, the parties viewed some properties in Scottsdale. On the evening of May 20th, respondent invited petitioner over to his home, which she accepted, which is so funny that nobody ever really honed in on the fact that she was the one sending him the nudies.
Oh, the lewds?
Lewds. That's the word, because I don't know that they were nudes. They were lewds. Lewds. Yes. That, like, it was mentioned once and then never brought back up again.
Yeah, I don't think it was a matter of contention because you don't want to submit those. So,
well, I guess, but it almost makes it sound like he was initiating everything.
right.
During that evening, both parties agreed that petitioner performed oral sex on respondent to completion twice. Like, this is a family court judge who usually oversees child support issues and things like that. And I mean, I know they have to ask who were your prior partners and things like that sometimes to determine it, but I don't think she has probably ever had to get this technical to talk about what you did, how you did it, and where it went afterwards.
In a traditional family court setting, probably not. But one where you're alleged to have made significant errors in saying that you're pregnant, then it becomes a matter of, interest.
That doesn't happen.
I mean, we've seen some pretty crazy family court hearings, though, Meg.
We have, but you have to feel for a conservative judge.
Oh, yeah.
Having to make those kind of statements.
In an order that will live on forever.
Yes, and I mean, not all judges are open.
I mean,
some
Duty
are
was
very.
During the order of protection hearing. Duty was like, I don't want to have to get into who took off whose shirt and whatnot, and
Yeah.
so to him, he was like, it really doesn't matter at this point, but it does to a degree if you want to figure out the what went down.
Like, if I just keep thinking, if my grandmother had to have this conversation, like, it would. I don't know that she could do it. I don't know that she could say that publicly in front of people. Like, she wasn't brought up that way. You don't talk about things like that. Hey, Helville, welcome.
Hello, hello. How's everyone doing?
Good.
It's a good day for justice.
Right?
It is. It is.
Finally.
Finally.
Yes.
Just when
So I think it's.
Oh,
go ahead.
sorry. Just when I was beginning to get productive at work again.
Oh, I'm sorry. You don't have to stay. I just
Are you
thought you
kidding
might
me?
want to play.
I am loving this.
I thought you might want to play with us.
Yeah.
Yeah, it just coming from a very conservative family in some regards, they would be mortified having to have this conversation or having to put this on the record. And this is permanently memorialized on a court record that will be there forever. Like, if she has children, if she has grandchildren, like 20 generations from now, if the world is still spinning, they can look back at this and say, oh, grandma swallowed twice. Like,
She's never
why
having
would
kids,
you do
though.
this?
Yeah, that's wild. I mean, my mom literally didn't actually even know like what, or like fellatio like essentially was. Like, when I was in my mid-20s, my sister and I were talking about how there was like a BJ's and a Dick's in the same shopping center, and it was hilarious. And my mom was like, why is that funny? I don't get it. And we're just both like, oh my God, we have to give someone an education on this. It's ridiculous.
Oh, that's rough.
Oh yeah. Oh yeah.
It reminds me of the meme where it's someone says, "Ooh, look, I found a photo of grandma," and it's like a black and white photo of a grandma sitting there in her black dress, looking all proper and whatnot, and then it says 80 years from now, it's like, "Look, I found a picture of grandma," and it's some girl at a club with half her breast hanging out or something.
I've seen that. Oh yeah.
Okay.
Not
You
wrong.
can't bark and then run. It's true. It really is true. Okay. So now he invited her over. He was high. He offered her one. She got high. Ziggy, come here or stop barking. Dogs. Swear. Late in the evening. Always did that twice.
You were at the completion, so petitioner testified. Yeah.
She did not want to have sexual intercourse, but that respondent stuck it in briefly. That infuriated me.
Oh yeah,
Like-
me too. How dare she?
Don't. Yeah. Really? Like,
Well, to be fair, she's a fairly daring person. I'll give her that.
well, she is in so many regards. But then afterwards, does she like have buyer's remorse or something? And because that's what she was making the claims against Mike Maricini, is that, he did all these things, while we were in bed, and, I wasn't comfortable with it, and I was scared of him. Well,
I think it's more so
she kept doing it.
she fictionalizes a bunch of stuff that didn't actually happen in order to paint herself as much of a victim as possible to make TEDx talks and have something on her resume besides just being daddy's little rich girl.
Yeah. She doesn't want to be in her dad's shadow, so she's got to.
So I'm wearing
Salem?
my Salem shirt today on purpose.
What does that mean?
The witch trials.
No,
Oh.
no,
Yeah.
there are good witches though. That's not nice to witches. Okay, she
No,
Yeah.
is a
There's
heartbeat.
way more good witches.
I'm
hag.
not saying she was one of the falsely accused witches.
Well, no, but there are good witches out there. She's a hag. She's just like
Yes.
a harpy or a hat. She's just a succubus. She sucks the energy and money out of every man she meets and his stuff too.
Well, if all of her claims were true, she's got like enough for a baseball team. But I think in reality, the answer would be no.
I think the proper term, she's not a succubus, she's a siren.
Yeah, that's probably true.
Yes. Lures them in and then is toxic.
Maybe she's like a hybrid between a siren and a succubus. Like once she lures them in, she like sucks them dry of everything. She's a rare breed.
Yes. The begging for them to stay. And I will say that victims in abusive relationships sometimes do that because they become kind of brainwashed and dependent on the person, and they feel like there's no way that they can live without that person in their life and supporting them.
Yeah.
So in those cases, sometimes that happens, but these are people that she barely has a connection with, that she's getting attached to and begging to stay. So if there was abuse and things that were making you scared of them in that shallow of a relationship, there's no possible way you would stay. You can't develop those attachments that quick.
Well, and that's kind of the whole point of my Salem comment, is that it was literally this whole thing built on lies. It was a whole ordeal, and people died built on lies. And here we are,
True.
hundreds of years later, and we're allowing people to do very similar things. It's not lost on me.
Okay. So after he stuck it in briefly, she initiated without consent and was not alleged initially in the court filings. It was not alleged until 2024. Yes. And over a year later was when she first made these allegations. And at trial, petitioner testified that the parties had sexual intercourse and that it was
Yeah. So that's one of the interesting things, is that this suddenly came up as a thing, but when she made the initial filing, there was a checkbox that says, was domestic violence in this, and then there was
right.
nope.
Well,
Yeah, no.
also, it only started to come up in her deposition, and she didn't actually say that word. She said, well, it is a definition. That does not mean that that's what you're alleging, right? Like that's confirming that what you're alleging is a definition of it. Like that was a weird way to put it, in my opinion.
The way it was written in the motion too, where it was first brought up, was a little interesting. It was like, I'm not going to accuse him of anything, but it would be classified as that.
Yeah, exactly.
Okay, so if you're not going to accuse him of anything, then why are you mentioning it?
Yeah. Also, she was on top of him. If they were naked grinding and she was on top of him, pretty sure she was in control of what went into her.
Yeah.
So, yeah, no. None of it lines up. None of it.
Unless Clayton has like that perfect precision, hit the right
I'm not
spot
going
every
to
time.
comment on the mechanics of
So many
that
men
kind
do.
of thing.
Because like, how many times have you hit the right spot exactly the first try every time?
Ooh, yeah, not many times.
Yeah, no.
No.
I mean, it needs a little flight navigation. Anyways,
I plead the
Commissioner
fifth.
Come on, Brad, tell us about it.
She should have done that.
I continue to assert my Fifth Amendment rights.
50%. Good stat. Yeah.
Oh yes, the
Some
dry.
people are just very lucky.
If that was if that 50% number was
Oh.
accurate, then everyone in the club would be pregnant.
He had a GPS to the G spot.
He's got that new technology. It's what being famous gets you.
He should share it though.
Yes, the Tomahawk Cruise. Oh, y'all. I don't know what I'd do without you. I don't know what I'd do without you.
Well, we know this ain't monetized, so might as well just get it all out there.
Somebody's not paying the light bill this month.
Oh, is it marked already as not monetized?
Oh, I don't know. I'm not even looking. Don't even have it up. Whatever. You know what? The road we've been down, it'll be fine. Okay. So she testified respondent was too high to remember intercourse due to his voluntary intoxication. How do you know that? I mean, some people can be stoned out of their mind and still remember that.
Well, she's testifying on his behalf about something that she cannot know, first of all. And second of all, wouldn't that indicate that she actually took sexual advantage of him? Just saying.
Yes. Didn't they say that on Cross, I think?
I don't remember, but that's
Sandra brought
usually
that
not
up.
how that works.
Yeah, I don't remember
Yeah.
either.
I think they did. Okay, so she believes she became pregnant on May 20th. She testified that after May 20th, her menstrual period stopped and did not resume until November 2023. But she also testified that she didn't get one. But that's okay. Petitioner has had PCOS since the age of 17 and does not have regular periods. Which someone was mentioning earlier that is something you live with every day. And I've met a lot of people since I was diagnosed with MS who have other chronic health conditions, and quite a few have had PCOS, and I'm not going to say debilitating, but
It can be.
it can be debilitating. And
I have PCOS, and it might not be like I don't have actual cysts, but I do have the inclination to develop them, I guess. But it does mess with all my hormones. So I deal with like the weight issues and the acne issues and the hair growth issues and all
hormones.
that stuff, and probably fertility, but I've never been tested because I don't want kids. We don't need a baby Hellville. So
Darcy, I think you might have just solved all my problems because I set stuff down and I can't find it. I looked for my phone for an hour yesterday and I sat down at my desk like, I don't know where it is. It's sitting right in front of me on the stand where it always is. Yeah.
I do that a lot.
So maybe this is the key to not losing things anymore.
Just get stoned.
But that's interesting that you say that it messes with your hormones because hormone fluctuations
Yeah. So it's a daily
are
thing. It's
a
a
huge
daily
thing.
Yeah.
I can't tell you how many pregnancy tests I took when I had it. I thought I was pregnant, and I wasn't, because nothing's regular.
It's true.
Tech nerd humor.
Austin.
Love you, man.
I have probably the same amount of PC operating systems.
But having those hormone imbalances could make her latch on and have those like overwhelming need to pull these people in. I have to have him. I need him. I need him. That obsessive, almost compulsive need to have this person to get hyper focused on him.
That
I
makes
think
a lot
once
of
they
sense.
reject her, she doesn't even necessarily want them anymore. I think it's more of like an obsessive need to get revenge on them for rejecting her, in my opinion.
But after Greg rejected her the first time, he blocked her.
Mhm.
And then he unblocked her and came back, and she was fine with it.
Yeah, but I think that she holds the whole relationship thing over their heads more as a torture device than because she actually wants it.
She was fine with it
Gotcha.
because he came back. And as long as he continues to play the game and stay with her, then she's fine.
That's what I'm wondering. Is she willing to forgive them if they come back? Like if at that hearing Clayton would have said, "Hey, let's just forget all this and go get lunch," would she have jumped in the car?
Yeah. Especially if it's burritos.
She hasn't had one in a really long time. She basically like disappeared weight-wise. Damn.
Oh my gosh. She's eating like one piece of lettuce a day or something.
Yeah.
I don't know.
Also, that's really hard to achieve when you have PCOS. So, I mean, is the PCOS even real? I mean, all of it's up for question because literally she lies about everything. So,
I think it goes to her digestive issues. That's what I think it goes to. I think she's got like a lack of thriving because
I know
of
that
IBS.
the Ponscom Posse did a deep dive on the scale that she posted the 91-pound figure on.
Oh,
and
yeah.
that supposedly came from a online pharmacy that also specializes in Ozempic style semaglutide injections.
yes.
So
And on top of that, those were not her toes, according to Poshmark. Yeah.
But if you looked at her at the hearing, I mean, she was nothing.
That's
And
a
in some of
believable
those
weight.
pictures,
Yeah, so I do believe the 91 pounds because she's so tiny. The only thing that has any weight is her giant head. But like, and maybe her distended belly. I don't know. But in general, it's just like, I believe she weighs 91 pounds, sure. But why take someone else's feet on the scale? Like, I don't know. It's just very bizarre.
I think she can control her weight. I think she can eat a lot and make it go up, or she can a couple shots of Ozempic and get right back down.
There's also the PCOS bloating, and also she has a gluten intolerance, so
Yep.
she bloats from that too. Well, I mean, supposedly. I mean, I guess we don't really know, do we?
We don't know any of it. It's impossible.
Yeah. But we do see people that are like, there were some videos of people that are really skinny that eat a little bit of gluten and then they look like 6 or 7 months pregnant really easily. So, yeah, I mean, could come from that very easily.
I went down that rabbit hole pretty hard. And those it can last for 12 hours. It can last for 3 days, even longer. It
Yeah.
just depends on, factors.
How fast your system processes.
Yep.
Long enough to take some weird videos and send them to your victim and then be fine for horse jumping competitions and then eat more gluten and take another one of those videos more bloated.
I mean, if it's a matter of whether you choose to have a burrito that day or not, then
Uh-oh.
Anything is possible in this day and age. It is.
Never know.
And I'm not even going to touch that comment. But I'm glad to know you retain your memory despite your level of intoxication. That is excellent to know.
That's a lot of pot.
Yeah. Especially if it's not built into an edible. And if it is, that's a lot of brownies. Okay. She has a history of epilepsy. I really would like to dig into this at some point in time because there's the falling off the horse. I'm sure she got hit in the head as a child sometime because
There was a story about her falling on the way to school one day.
Well,
Where did
she
it-
falls off horses all the time, apparently.
Yeah, she fell on the way to school one day in high school or something.
Yeah, so there's stories of slipping on black ice in San Francisco. There's the car accident, but the first recorded notion of an epileptic episode is a month after the car accident. She said that she had an epileptic episode. So that's really when she started talking about it, and whether it's conclusive or not of that she truly had an episode, or if she claimed it and then continues to claim it going forward. Because that
now
also
wasn't that in the same time period as she was dating Mike Maricini?
Yeah, so she actually texted him. That's the first time she admitted to anything about seizures.
Yeah.
She texted him that she had a seizure, or he had witnessed the seizure, whatever it was, after she fell off a horse or something. And then she's like, it must be from the accident because I've never had this before. And that was like from several months prior to when she started accusing him of causing the epilepsy in her video.
that was 4 months after the Iceland trip, and then in the TEDx talk she said,
Right.
"Oh well, I was in the hospital because he beat me so bad."
Right. Yes.
Yeah.
He
Exactly.
I say that's Exhibit A in Mike's case when he sues.
I
yeah,
think
that's
people should
something we
sue
need
her
to
for
look
defamation.
into, dig into after this. I'm sorry.
Yeah.
Okay. So the 2 offers on the property, we know about that. He tried to pass her off, wouldn't pass her off. She called the real estate board, positive pregnancies, Banner Health. Couldn't have been anybody else's kid. Wasn't there something they kept? I heard them talking about the something to consider email a bit. And the something to consider email, the court finds that the language to imply respondent was attempting to buy into the idea that rubbing or grinding their genitals together might have led to pregnancy. Exhibit A2. The court, however,
So it's
might have led
this
to
is an email to Clayton to Laura talking about the pregnancy, and he's like, I don't know how this could happen and whatnot, and it's him trying to rationalize what was going on. And the court says this is not conclusive proof that he believed her. This is him walking through it in his mind and putting it on paper.
immediately after it happens.
No, this was weeks prior, so this would have been like mid-July.
Oh, okay. Petitioner denies sending respondent an ultrasound video, citing instead Greg Gillespie hacked into her email and sent the video to respondent. And then she testified at some point that, why do you think that this happened? Well, he has hacked into other people's email before.
Defamation.
Admit that. I would like to
That's
see
your
that.
basis? That's all you got?
Are we going to see the exhibits eventually, do you think?
We've seen most of them already.
Yeah,
My brain works weird. I
would like
I
to
think
see the depositions, though. I hope those will get released. Well, we don't need Clayton's. He always tells the truth.
They should be released in part of the file as it's closed out, unless there's confidential information they ask for it to be sealed, and then they may redact it.
But everything she says is lies, so why would that be confidential?
Right.
Hey, MG. Welcome to the party. Okay. She anonymously sought care, which she failed to provide any records. Planned Parenthood, anonymous. We know that. Mission Viejo, then now all of a sudden it's Los Angeles because, you know, she just can't tell the truth. Telehealth, HCG, Dr. Pools, records. I love that. 45 pages of records confirming making and canceling appointments.
You wonder what's wrong with our medical system,
You're a
and
rock
it's
star.
how can 4 making and cancellations of an appointment cause 45 pages of records?
Yeah.
I probably, as the actual facility, would have like blocked her at some point before that.
Right. Like, stop calling here. We don't want to see you, actually.
Yeah.
Like, if
I mean,
you
I
can't
don't
keep an appointment,
think they
you're
can do
just
that,
wasting your time. Because
Well,
like
they
if you-
charge you a lot of times.
but also, I mean, even if she didn't reach the point yet, because usually it's 24, 48 hours before they'll charge you.
Mhm.
Like, just even in general, like, I think it's like completely wasting the resources. If she was calling in, that's taking up the secretary's time. If she was making it online, there's still someone there who's coordinating it and adding it to the schedule. So it's taking up everyone's time and effort. So it's just like stupid. Like, I would block her personally.
This section is one of my favorites in this.
The doctor's like, hey, you see that bitch over there in the lobby? Block that bitch.
Yes. An in-person blocking. How epic.
I missed that. Wait, what?
But she never went to the lobby.
Oh, that's right.
She got COVID, which
That's right. Okay. Well,
has no medical
you know.
record.
Hey, you know that bitch? Sorry. Okay. During petitioner's cross-examination, it became profoundly obvious that counsel for the petitioner was attempting to coach her answers. Is this where I'm supposed to start? Right?
Yeah. Respondent's
counsel, identifying the issue, moved between counsel and the petitioner. From that point forward, the petitioner began to exhibit extreme anxiety and unwillingness to answer questions. The court had to remind the petitioner twice that the counsel would ask a question and she needed to answer it. But that's not fair. She should be able to ask a question back. She was very entitled in
If
that.
I can't dramatize my answer, what's the point?
Yeah, but I watched King. You could see him. He was going like this, telling her when to calm down, and then he was telling her, "Okay, go." Like,
But you're missing
Ramp
the
it up. Keep
context.
yeah. God, I can't even do it. Her voice. Ugh. Jeez, this stuff that gives you nightmares. Okay. Put that on the record. So now, as part of it, they're going to say that she lost eye contact with her support system, and that gave her anxiety.
Everything gives her anxiety.
Bullshit.
Anxiety gives her anxiety.
Yeah. The court had to remind her. At this time, petitioner pushed back. Blah, blah, blah. I read that already. At this time, the petitioner became very emotional. Oh, I added the very sorry. And asked for a brief recess, which the court granted, even though it shouldn't have. The court finds this interaction between counsel and petitioner diminishes the credibility and veracity of the petitioner's responses during cross-examination.
Uh-oh.
She kind of did that on her own, but good job, Gingras, stepping it up a bit, making sure. Wow. I don't know that I've ever seen that notated in a court case, ever. Like, your attorney helped you be uncredible. The court finds it impossible to determine the date of any alleged miscarriage. Gee, I wonder why. Not because it is impossible, but rather because she failed to seek even a minimal level of care for her high-risk condition. Failure to demonstrate confirmation of ongoing pregnancy is a purposeful way to ensure respondent would not be able to determine if she was pregnant, or if so, for how long the pregnancy lasted.
Or if it was his.
Or if there were two.
And if they were a boy and a girl.
She wouldn't have
Oh,
even known
Mitchell.
because none of her alleged ultrasounds were even at a point where she could determine that.
Well,
All of her alleged ultrasounds weren't hers.
They were fake.
even taking a baby, a fetus out of it, anybody who has all of those medical conditions would be simultaneously seeking care to make sure that whatever happened didn't further damage their body or make their condition worse. Like the fact that she just didn't go is perplexing to me.
I have ongoing
Anyone who had
my stuff. So yeah, that's accurate. If you actually have these conditions, you seek medical care on an ongoing basis, and you
Yes.
make appointments all the time.
Yep.
every 3 to 6 months. Like
Oh, mine's more
clockwork
frequent than that. But I will say, like, it's
at a minimum.
yeah, exactly. It's like I have so many medical records, and she couldn't produce any.
Yeah,
I
seeing
have a
an OB-GYN,
5-inch binder.
right?
I've never printed mine out, but I probably would have a pretty thick binder.
Brad, you want to read for a minute? You're muted.
Yeah, sure. Where at?
Top of the page.
Okay.
Dead chill.
Dr. Michael Medchill, MD, a retired OBGYN and prior chair at St. Joseph's Hospital, testified that pregnancy is possible without sexual intercourse. Dr. Medchill testified that he delivered 30,000 babies during his practice and saw many patients for miscarriages.
Didn't we
The 30,000 is, yeah, that's contested because it somehow went from 20 to 25 to 30,000.
Yeah, it was 20 to start, right?
Yeah.
Yeah.
And even at 20, it was not possible because he would have had to have been delivering like what was it? Like 20 babies a day?
Do you think he includes any like miscarriages that people of like patients of his experienced as also delivering babies?
But you still, how would you have
Doubtful.
to treat that patient that takes up time in your day? How are you going to go through that many?
I don't know. I was trying to give him a little benefit of the doubt, but there just is none, is there?
No,
He
the
needs
guy
to
that
be in
No.
like Olympic gymnasiums where women are in beds side to
one
side
guy
delivering
to the next.
babies,
Boom, boom,
just
boom.
rolling down the line on his squeaky chair trying to
Sounds like a horror movie that I do
Like a
not.
Guinness World Record type event.
right.
Yeah, the guy
A
that
lot of
holds
amniotic fluid.
the record, his number is like 19,000, and he practiced in Chicago for like 60 years. Like his numbers they don't add up.
Yeah. So
Neither do
Doc-
his definitions. So
Well, true story. I mean, anybody who believes in virginity examinations is a quack.
the only way I can think of that is it says he delivered, but if someone else delivered it and he was just in the room, like that would be the only other thing. But then he's lying because he didn't personally deliver them.
But he still has to physically be there. Like there's not enough hours in the day to be present for all of that.
Yeah, that's like if you're part of a practice and you take credit for every baby delivered by your practice.
That,
maybe that's what
That.
he's doing. That might be it. Maybe
Still
we've
don't
solved
see how
it.
it's possible, but yeah.
like every baby that got delivered in the hospital, that's what.
Right.
Yeah, the hospital he worked at, he delivered every one of those babies, even if he didn't deliver every one of those babies.
Yeah.
That's the
Dr.
only way
Med-
papers work. Sorry, continue.
No, you're good. Dr. Medchill testified that he reviewed approximately 200 pages of petitioner's medical records from Barrow Neurological Institute in Phoenix, and that included summaries of the petitioner's medications. He did not, however, review primary care or historical OBGYN records. Dr. Medchill testified that none of the medication records he reviewed would cause a false pregnancy test. Dr. Medchill testified that a false positive HCG test could be one of the result of epilepsy medication, anxiety medication, clozapine, horse urine, or IVF prescribed injections, trigger shots. When asked by
Horse
the court,
urine?
so supposedly there's some drug that's produced from horse urine that could be given to try and get induced fertility. But
Oh, gee, I wonder what she has easy access to. Could it possibly be horse urine?
I don't
How
think
exactly do you get that from the urine to your body?
I think it has to be processed, but I don't think it's something that a normal 30-something without a lab is going to be able to do.
Okay. Because I did talk to a couple horse people who told me they don't use standard HCG to for fertility for horses. They use a different drug. So that was interesting.
Sorry, my dog has decided that she wants to go outside 14 times a day in the hottest day of the year.
Yeah, so without risk of completely destroying my search history, I'm just going to move past that one.
Okay. Yes. Please. I don't want to go down that rabbit hole.
When asked by
I
the
did
court,
the fake pee one. That's my max.
Dr. Medshill testified he did not review any Planned Parenthood records from Mission Viejo or Los Angeles facilities. Dr. Medshill testified that a home pregnancy test can detect pregnancy 11 days after conception. Dr. Medshill testified that he is 99.9% sure that the petitioner was pregnant based on the HCG test. He did not change his perspective after petitioner's admissions of falsifying evidence and... Can you scroll, please?
Oh, sorry. I took my glasses off. I couldn't see.
A false positive, yep, due to several medication, or no, up a little bit. There we go. He did not change his perspective after the petitioner's admissions on the stand that she altered more than one test to reflect higher viable HCG numbers. The court finds Dr. Medshill's testimony that 0.1% chance the petitioner received a false positive due to several medications she is in fact taking, possible trigger shot for HCG, and a prior history of ovarian cancer to diminish his credibility, especially given the records that the petitioner testified existed were not presented to her own expert for review or in consideration.
That's what's messed up.
Dr. Medshill testified that the blood HCG level of 102 is proof of a non-viable pregnancy, while Dr. Medshill testified that a non-viable pregnancy is still a pregnancy. The court finds that altering the number to reflect 102,000, which would be a viable pregnancy, to indicate that she intended for the respondent to believe that she was still pregnant with viable fetuses.
Which is a problem.
Yep. Dr. Medshill concluded that the petitioner became pregnant on May 20th, 2023, and ended with a spontaneous abortion in late October or early November, or possibly sooner in 2023. Given the alterations of the only medical records to indicate pregnancy, the court does not accept this conclusion.
Boom.
Dr.
Sorry,
Medshill
expert witness.
Yeah.
Well, that's why she questioned him on the stand. That was pretty epic.
Well, that's not unusual in a lot of cases.
But the question she
Certain
was
jurisdictions.
asking, like
Yes,
the
it's
questions
very-
she was asking just were a supplement to Woodnick destroying him.
It's like, tie this up for me. Here's
Yeah,
my bow. Okay, thank you.
Exactly.
Dr. Medshill testified that women may expel tissue during spontaneous abortion, or the pregnancy might remain in her body, ultimately being reabsorbed.
Who?
Hmm?
Is Brad pregnant?
I am not pregnant.
He just took a pregnant pause.
No, I can't read anymore because page.
He just
Oh.
took a DNA test.
I just took a DNA test.
Turns
I
out.
swear I've had that song in my head for
Well, Dave keeps using that button on his
He
live.
keeps using the button, so. Given the petitioner testified under oath at a prior hearing that she was absolutely 24 weeks pregnant and has been seen her doctor, presumably in person, the court does not accept that 24-week-old twin fetuses would be reabsorbed into a mother's body. The court further finds a miscarriage at that stage of pregnancy would result in emergency medical care and corresponding death certificates of the twins. If what Dr. Medshill testified is true, she miscarried much sooner, negating the need for the death certificates, then the petitioner perjured herself at a prior hearing.
boom. Mic drop. I
Okay,
mean, that's
so
all there is to it.
Like this comment, I have a feeling there's burritos and all
Hey,
sorts
Alita.
being thrown all around the casita.
I heard some screaming all the way over here in Florida. So it was echoing a little bit off the water. I think that's
I
where
was
it's coming
wondering
from.
if we're monitoring the police chatter in Scottsdale for a possible fire alarm at the casita.
Did I tell you guys I found out how big the casita is? Did I tell you about that?
What
No,
happened?
it's the pool house. Can we
It's a-
stop calling it the casita? It's a freaking pool house.
It's
pool
398
house.
square feet.
Do you remember how
It's a
when
studio apartment.
Carlton
It's smaller
and
than that.
Will, Carlton and
hotel
Will
room.
got put in the pool house? It's a pool house.
Yeah. It's a bedroom with a kitchenette.
Yeah, it's a storage shed with sliding glass doors.
I guess you know why she always wanted to go over to Clayton's house.
Okay, so we know what Samantha Dean said, right? There's nothing fantastic in here.
No, she just confirmed actual medical science.
Yeah.
Yeah.
I mean,
that one was interesting. Heterophilic?
Heterophilic autoimmune responses.
That's kind of interesting. Can produce.
wouldn't she have to be
HCG
diagnosed
cells?
with an autoimmune disease in order to have an autoimmune response that would be medically confirmed?
Actually, no. Right,
Okay.
Meg? Yeah,
Okay.
you can have autoimmune symptoms from a different autoimmune disease if you have another autoimmune disease.
But she
Isn't
hasn't been confirmed.
PCOS
that
autoimmune?
I don't think so.
No.
PCOS isn't an autoimmune thing.
Yeah.
Oh.
She
But
doesn't
her
have any.
celiac?
That could be, I think, right?
Yeah. I believe so.
But does she have a diagnosis from an actual verified medical?
No, and that doesn't mean anything. But
I mean, she might have one on paper.
Yeah.
and
Is it legit?
it's also very common to not be diagnosed with an autoimmune disease. When you have MS is autoimmune to the hilt, but it takes years to diagnose. Some people have their first symptoms 10 years before they actually get a definitive diagnosis because there's no single test that shows it.
It's a diagnosis of elimination. So they have to eliminate everything else before they can diagnose you with that. So
Mhm.
And that's if they believe you.
yeah. Oh yeah, there's that too.
My hand's tingling. Okay.
Right. Yeah. Yeah.
Everything Clayton says, which,
The truth.
they go over the fact that he lied about submitting the offers, but who really cares?
And this, I still can't get over the fact that they hung their hat on this to a large extent, but it worked. Like
And
this
this'll
was
get
their
awkward.
proof that, yeah.
Don't put that in writing. That's the lesson. Why would you put that in writing?
Got too cocky.
Miss Owens, just lie.
Woodnick had to have been saying to himself, I can't effing believe that I'm about to stand in a court of law and say this, but Clayton,
Here we are.
Well, this will get awkward.
And this'll
have you
get
been in there
awkward.
before? So you're saying you've never been in there before? When I heard that, I couldn't talk. I just was like, yes, this is what our court system has come to.
Well, I'll tell you what I like about everything Judge Mattis said, to be honest, is that everything we've been screaming at each other in our screens and on texting and tweeting for 8 months plus, it's like, yep, she saw it.
She addressed
It landed.
everything.
It landed.
Everything. Yeah, you're right. It was very satisfying.
Yes.
Except I wish she would have overturned his order of protection.
She
I
can't.
think she thought she doesn't have the ability. I think she really thinks she
So-
doesn't have the legal.
I think she
that-
does have the ability, but
Maybe she didn't want to push it too much.
yeah, probably.
At the bottom of this, that goes into the validity of the order of protection, and it goes into the legal justification as to why she believes she can't do anything with the order of protection, and it basically amounts to, I'm not an appellate judge, so therefore I can't make a ruling on that, even though it's because it's an appellate issue, it is not something that I can edit
I think she
on the same level.
documented for the record something that can be used in his appellate case when he.
Oh yeah,
appeals it.
absolutely.
Yeah.
If they
But it
can
was
appeal it,
It was a magistrate judge that entered it in, correct?
A commissioner.
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 A commissioner. Okay, so A commissioner is actually an attorney who has been given special privileges to act in the capacity as a judge.
Sure what she was. So thank you for the definition. I was like, what is a commissioner? I don't even know.
Yeah, they weren't elected and put in the seat of a judge, but so many of the courts got so backed up. Actually, I don't know how long. It may have been going on longer than that. I don't know the history of the program, but I know that they have been working a lot to help the courts get caught up on cases that still from the backup from COVID, because everything just got, log jammed, and slowly you work it off.
Well, I think it was backed up before COVID too.
Oh yeah. Our courts are so overwhelmed.
Oh yeah.
And so they're not a judge. They weren't elected or appointed to the position, but they're still acting in the capacity of a judge. And in that capacity, they're still on the same level as the other judges who are hearing the same types of cases. So she can't go over to her colleague that's on the same level as her and say, hey, I think you're wrong. So I'm just going to throw this one out and, we'll do it again.
Well, I think she's trying to especially play by the rules because of how litigious Laura is and how unhinged her attorney is.
And I don't know that was actually put in front of her either. I don't remember that actually being in a motion to overturn that.
Greg Woodnick in a motion to combine all three of the cases.
Oh, that's right.
The IAH only for the purposes of fees and sanctions, but he wanted the other one, both fees and sanctions, and overturn the order of protection.
Gotcha. Okay. So
I know too much about this.
One of the
hey, have you read this before?
One of the pieces that this talks about is the fact that even though there may have been fraud for the pregnancy action, a part of the statute that goes over the orders of protection says that if there was sexual contact between the parties, then that automatically makes it a factor that can be adjudicated on.
Okay, that makes sense too. Okay, so it's going over the basis from the Vera Rogers. Vera, if anybody wants to read it, it's Vera v. Rogers. Hold on. Let's see. I had the site right there. Vera v. Rogers, 246 Arizona 3, Court of Appeals. Stop. 2018. Okay. Sanctions.
Oh yeah.
Arizona rules. What does the F stand for?
Family court?
Family law procedure. 26B.
Family law procedure.
Oh, 26B. Ooh, 26B.
26.
Rule 26. Rule 26.
Rule 26. Watch out.
Emotional
Provides.
support.
I know. Where's my dog? Provides that by signing a pleading, motion, or other document, the attorney and party certifies to the best of that person's knowledge, information, and belief, formed after reasonable inquiry, 1, that it is not being presented for any improper purposes, such as to harass. 2, the claims, defenses, and other legal contentions are warranted by existing law. 3, the factual contentions have evidentiary support, or if specifically so identified, will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. Meanwhile, Rule 26C provides that if a pleading motion or other document is signed in violation of this rule, the court, on motion or on its own, Jingers, you hear that? May impose on the person who signed it, a represented party, or both, an appropriate sanction, which may include in order to pay the other party or parties the amount of the reasonable expenses incurred because of the filing of the document, including a reasonable attorney fees, emphasis added. Meaning, if you lie, if you attempt to harass, if you screw around, if you F around, you're going to find out by paying them. The end.
Yep.
In this case, respondent filed a motion for sanctions pursuant to Rule 26 on January 3rd, 2024, arguing that petitioner filed the underlying action for an improper purpose without medical evidence to support her claim, and that claim that she was pregnant and or that she was pregnant by respondent. Docket number 1. However, after significant motion practice between the parties. Significant is an understatement. You mean after 557 motions? Respondent filed a motion to withdraw motions for sanctions pursuant to 26 on April, retaining his other claims. The question thus becomes, can the court still award Rule 26 sanctions considering respondent's withdrawal of his motion? And I think we talked about that before. He was withdrawing that to try and simplify things because it was getting out of hand, the number of everything back and forth. And I mean, there really wasn't a huge issue, but they were trying to make it a huge issue.
Right.
Yes.
As already noted above, 26C expressly provides that the court can sanction a party for its violation on its own. The court was unable to locate any decisions pertaining to whether the withdrawal of a party's Rule 26 sanction motions precludes a sua sponte court award. But in a matter of plain meaning, the strict interpretation, it would seem not to matter whether the party ever files a motion, or even whether the party does file a motion and then withdraws it, a court may still award the sanctions it deems appropriate based on the conduct it deems to violate the rule.
AKA, hey, stop filing crap about this rule, Ingress, okay? I can do it.
She's like, bitch, I can do what I want.
Read the rule properly.
Yeah, that's his issue. He was confusing civil and family law. I really believe that, and they're just slightly different.
Not
I think
even
in
that.
general, Sorry, go ahead.
I'd say he brings in federal rules way too much as well.
Yeah.
He's like, well, this is how it's done in federal court. And it's like, great, well, you're in state court now. So do state court stuff now.
But I think, too, it's like he kind of like sees one thing and then he rushes to like publicize how amazing he is that he found this one little thing and like doesn't read to the end of the sentence where it like actually defines everything.
He didn't read the fine print.
Sovereign
Thank you so
citizens.
much.
Holy cow.
Oh.
Lucky.
You're the best. The pups are like, steak tonight. Nope, they're still passed out. Thank you so much. I appreciate the support so much. It means a lot. Always.
He might have a new career in YouTube sovereign citizen lectures. Right? Where you take
Maybe that's
parts
his
of
goal.
things and mash them all together and make it work for you.
Yeah. Where you take one law and you completely misinterpret its meaning and try and make it apply to your situation.
Yep. He's good at that, actually.
Mm-hmm.
He also was answering tweets about how Greg is like a law professor, like an ethics professor. And he was like, well, I've taught some classes. Does that make me a professor? No, Gingras, it does not. It does not. No, that is not your job. No.
Someone asked, I think I caught a few minutes of Megan Fox's stream this morning, and someone asked what law school he went to. And I think it was like San Francisco law or something like that.
Yeah, he went to ASU and then he went
community college law.
And someone mentioned that he got his law degree at Trump University, and everyone had a good laugh at that one.
Oh yeah.
I asked an attorney friend of mine, you know, what is that? How does that stack up? And they said it's about the equivalent of getting your law degree written in crayon on the back of a Denny's napkin.
Sounds about right. Well, he is a transcript lawyer after all. So
I said, well, I wonder if he hung it on his wall.
Mommy, can you put my degree in your fridge?
You can't do handprints in crayon, though. You got to have that finger paint for that.
Depends on the crayon. If you get the professional artist crayons, you can definitely leave
rub
marks.
it on your hand.
Oh yeah.
That could be fun. Maybe they had arts and crafts time together.
Probably so. How do we get out of this session?
Right before nap, right after center time. So, yes, the court can impose sanctions if they feel like it. And we do feel like it because the court, we're here to find that the petitioner fabricated her, if the court were to find that the petitioner fabricated her pregnancy in order to provide leverage against the respondent in order to Oh, I just totally made those words up. To provide leverage against the respondent in order to secure a long-term relationship with him and all its attended benefits. I think
Yeah.
that's a pretty, like,
That's one of the most damning statements in there.
but it's also like a ego boost for Clayton. All its benefits, you know.
To be fair, he's been knocked down for many, many months. He maybe needs a little ego boost here and there.
I like it. I know, but I like it. Like, it's like you would get a lot. You would be dating up. Is that what they call it? Dating up?
It's
I mean,
dating up.
every one of these men she's been dating up or banging up or whatever, however you want to call it.
Stalking.
Climbing that
Following
totem
up.
pole.
Stalking up, yeah.
And that's an excellent point. Yeah. So not only are you wasting the court's time, but you are making the court talk about things that it is probably not comfortable talking about. And you are also like making
Lying
a
to the
mockery of so many different super delicate situations. People who have
Stolen
been
valor.
through hellacious things, losing babies, domestic violence, actual illnesses. You are bidding on those things, like openly, broadly, plainly, and
Dave and Megan are calling it like stolen valor. And that's
Yeah.
exactly what she's doing. But also,
It
on
is.
top of all of that, she's also lying to the court demonstrably. Like, that pisses the court off, I would think.
Yeah.
Slam dunk, really, for
it is. It is so offensive. It is so offensive.
Oh, yeah.
I am offended beyond words in some of these instances.
Yes.
She has no idea what it's like to actually suffer through those things. She may have suffered through her own things, but I assure you it is nothing like those things that she is claiming. And it's disgusting. It is absolutely disgusting.
That's the right word.
Sorry.
Perfect word.
So I can order attorney fees if I want to because I'm the judge.
And Rule 26 allows me to.
David's rule. Oh,
Although there is a dearth, is that dearth? Dearth of case law on this issue. It's not a word that I usually see in. I think like plethora or abundance. There sounds like a negative word. Hey, can one of you guys read for 1 second?
Other rules confirm that family court has the authority to award sanctions on its own. Rule 76-2A sub 1, for instance, provides that in a pre-judgment or post-judgment proceeding, the court, upon motion or its own initiative, may impose sanctions if a party or attorney 1. Fails to obey a scheduling or pretrial order, 2. Fails to appear at a resolution management conference, a scheduling conference, an evidentiary hearing, a trial, or other scheduled hearing, 3. Is substantially unprepared to participate in a conference, hearing, or trial, 4. Fails to participate in good faith and unprepared or in a conference, hearing, or trial, or in preparing a resolution statement, scheduling statement, or pretrial statement, emphasis added. And the remedies available include, in addition to substantive sanctions, ordering the party at fault to pay reasonable expenses, including attorney's fees and assessment to the clerk, or both, caused by any noncompliance with a court order. See those cases for whatever it says. Confirming power of court to award sanctions on its own initiative under 76. Rule 71 provides for a similar power. Additionally, as is evident from their near contextual identicality, and per the Arizona Family Law Rules Handbook, Rule 26 is based on Arizona's Rule of Civil Procedure 11, 3. Comparison with the Civil Rules, 13. Arizona Practice Family Law Rules Handbook, Rule 26, and Rule 11 also expressly provides that in the event of a violation, the court, on motion or on its own, may impose on the person who signed it, a represented party, or both, an appropriate sanction. And in the Rule 11 context, the Court of Appeals has concluded that a trial court may impose sanctions even after a complaint has been dismissed for lack of prosecution. This lends credence to the idea that the family court's inherent authority to award sanctions under Rule 26 should not be read to be limited by the course of the case or by the litigation strategy pursued by the parties. The power is there by rule and can be used by the court when necessary and appropriate.
And when has it ever been more necessary or appropriate than right now?
Right.
I mean, every single one of those points, 1, 2, 3, 4, they were there.
Yeah, and Greg Woodnick literally wrote this rule.
Right.
He was on the committee that wrote this rule.
My legal authority has texted me to inform me that I am mistaken, and I apologize. Dearth means I can't find a case on point because this is nuts. That came straight out of Black.
Lack of. I Googled it. It's lack of.
Oh, interesting.
I
Excellent word use.
can't say I knew that.
Lack
Alrighty
of
then.
information to support this bat crap ridiculousness.
Don't forget to get your batshit crazy shirt in
T-shirt.
the Meg's merch shop. Megsmerch.com. Batshit crazy. All the best.
All the best.
Provides a man as a presumed father if he is the if genetic testing affirms at least 95% probability of paternity. Provides a man as a presumed father, DNA testing, blah, blah, blah. Little to no fetal DNA. And just to reiterate this, because I didn't know this initially, but the reason that they ended up doing the Ravgen and it was a big deal, and why she keeps saying twins, is because up until Ravgen came on the scene just in the past, I think, year, you were not able to do pre-delivery genetic testing or in utero genetic testing on twins.
Correct. The amniotic fluid for both twins is like flowing freely, apparently, so they can't guarantee who's the father of which one if there are possibly two fathers, which could happen. It's unlikely.
Which is a thing.
Yep. Sure is.
It's like the
Because
weird
you can
cases.
release 2 eggs and they can be fertilized
By
by 2 different people,
Oh, yeah.
you know? When you have
It's
one
like-
of those fun nights.
I've heard there's a very rare case where a woman has 2 uteruses and then each could be pregnant, and
How wide are her hips? Holy crap.
Does one of the uteruses belong to Laura Owens?
Thank you, Alan. She's already threatened. And I haven't said a single thing that wasn't true.
She doesn't have enough money to pursue anybody.
Yeah.
Oh, yeah. I love that financial deep dive. That was like my favorite thing. I was like, yes, I knew it. I knew it.
Yeah.
Go over to Law Talk with Mike. He'll tell you all about naughty adventures. So here 2 test results of little to no fetal DNA fall woefully short of the 95% required to meet the burden of clear and convincing evidence. I feel like there was a post by an attorney that
MG
said,
Law.
no, I think it was one from Arizona that said something about there was no standard that had to be met. There was no clear and convincing evidence, anything in this case. There was no legal standard.
MG went and found this establishment paternity regulation and said it's on her to prove the 95% certainty, so she wouldn't have met her burden of
Yeah.
proof regardless.
Oh, I didn't see that. Yeah, I found
That's
it
the
a
petitioner.
while ago. It was, but there was an attorney who said that that wasn't a thing. There were no standards. I'm
Well,
sorry, I must have
apparently
missed
there
where he
are.
said that.
So illogical.
I just thought it was ironic that the judge was citing those non-existent standards that, you know. So this is basically what he needs right here. This is your non-pregnancy
That's the
determination.
main thing he was looking for. So it's really super exciting that he can say that, and then she can never say, I was impregnated by the bachelor and he was abusive towards me and he was a deadbeat and blah, he caused a miscarriage and all this other crazy crap, you know?
No,
She
because then
can't say
he
that.
instantly has another defamation suit against her if she does try and say any of those things publicly.
Yeah, and
And-
he already has a clear one against her. I do hope he goes for it. I know it's like frustrating, but it would just be nice to like permanently shut her up from like hurting people, because that's what she does. She just hurts people.
Mm-hmm.
But it's also like Johnny Depp. He wants to clear his reputation.
That too.
Being falsely accused of something and being looked at, you know, all the bad stories went mainstream media, like to an extent. I mean,
That's
they got
what
a lot
they're
of press.
I
And
think
then
that
all of this support for him kind of was isolated on YouTube and a couple social media things. It didn't hit normal mainstream media to clear his name. So if somebody's not looking for information on him on YouTube or Instagram or Twitter, they wouldn't know that he's free and clear. They would
I
still
think-
think, oh, that's a jerk that knocked up the podcast girl.
exactly.
I think what's going to go forward is, if for whatever reason they want to pursue something further, I think they're going to offer a non-disclosure statement and say, we're going to give you a non-disclosure statement, and you're going to pay us $500,000 for this non-disclosure statement, and then you're going to not do anything to talk about Clayton and this matter further. And if you violate this, then we're going to come after a significant amount of money. And because if they did pursue a true defamation case, then that's their out for saying, then you're not going to, we'll go forward with this and you're not going to look very good.
Well, I do think he has a clear-cut defamation case against like who was it that published it? OK, or the Sun, whatever it was, because he said, hey, look, like literally none of this is true. And they said, well, all press is good press. I mean, they like destroyed him. And then they proceeded to not actually print really any updates on the thing, proving that it was a lie. So it's
They
the same
did retract it, but
before
only
out.
after it was out.
Yeah, but I mean, they ruined his reputation by doing that, especially by not actually checking on the veracity of the claims.
Well, there was no actual proof out there at the time. They could have done more, but I think as a journalist,
Their options are little because you have a woman who's claiming something and you have a guy who's trying to fight it. And without the time for a judge to go through all of the hurdles that we've already have gone through over the past 8 months, they wouldn't have been able to have those facts already there. So they just have to go with what they have and are
They
reasonably
published it
brought.
with her as the anonymous woman, and several other sources that she went to refused to do so. So they decided to kind of like shirk their duties as journalists. To be fair, like journalists suck these days, but
Because the problem is because she's fabricating evidence and presenting it to them, they can only do so much to get or attempt to verify the story. Because if they get presented, here's my ultrasound, here's this, and they go, okay, well, a normal person who would have these documents wouldn't have fabricated them, so they go off of the veracity of the person, and then come to find out that she's the one who's providing all of this false evidence, then they did enough due diligence to try and understand it.
yes,
think-
but that was the only publication that really like went ahead with the story with her as an anonymous woman. And they could have chosen to do the same thing as the other publications that decided to say, we can't do this unless we can confirm you.
but that doesn't mean that they broke the law.
No, I don't
Because
think
If
no.
she provided them, if she provided them the proof of her pregnancy, I mean, that's kind of sufficient.
Well, and I'm sure it's also in phrasing, right? If they say, according to this woman, this is what
Yeah.
happened, right?
Yeah.
Then I'm sure they
being
have.
unethical and in crossing over into defamation, or when it's journalism, it's
Like, we had to be careful on our deep dive. This is
yeah,
what we
they walked a
found.
tight line, but I don't think they retracted it once proof came out, and that covered their ass.
I agree with that. As someone that worked at paralegal, never
Please.
seen a pre-birth custody arrangement. It's wild.
State by state is how they determine it. Arizona allows you to file pre-birth, but there's other states that don't. Most states don't allow you to file until the child is actually born, to prevent things like this. Like, until this test can be done. So it's not drug on for 9 months, because you can incur like ridiculous fees. So it's all about the jurisdiction. And I think that should change. I think that's a huge issue that
Fully agree.
definitely this shouldn't be allowed to happen. And hopefully this is like an isolated thing, but
And some people are saying they should change it so that you can't file it without like a verified ultrasound. But I disagree with that. I think until you've actually produced a child, you shouldn't be able to sue for these.
a child that can be tested for DNA to prove the father
Yeah,
before you start dragging the father through it.
exactly.
I think it's pretty easy for requirements. You can't file it until after the first trimester, because that reduces because they say, what, 30% of all miscarriages happen within the first trimester, or some unreasonably high number is that if you're going to miscarry, it's going to be in the first trimester 9
Correct.
times out of 10.
If you're actually
So-
pregnant.
If you're actually pregnant. So
Yeah, because
if you get past that point, you could say, okay, you can file it, but then you also have to provide an ultrasound and or go through the paternity testing in utero in order to do it. Because there's nothing wrong with starting it there, but I think the issue is the fact that she's trying to start it so early without any of the proving parts that it becomes harder to justify. And because, like, when I was in the military, I was out processed and went through my VA in processing at the same time. So that ensured that the day I was out, I had VA benefits and my disability check coming in. So even though, yes, you can get back pay and whatnot, back pay is great. But the problem is if someone doesn't have that kind of money just sitting around, the sooner that you can get it started and then just say, you're going to start providing $800 a month once this baby is born, it's a lot more feasible doing it that way than to try and start it after the baby's born and then try and come after him for $6,000 later.
well, and
It
to
doesn't
that
take
point-
that long to establish paternity.
No, but to what he's saying, like, there also might be some insurance benefit factors that come into play too, right? Based on some insurance companies require.
Until
legal
the baby's born, though.
Well,
So instantly at birth. But
Like,
insurance
I don't
goes
know.
retroactive. Yeah, I
sometimes
guess we're not
domestic
that far.
partners are eligible for benefits if you can prove the domestic partnership without being married.
She can't prove any
Okay,
domestic
that's a
violence.
whole nother thing. All right, let's keep going.
Blew
Moving
your
along.
mind, didn't I?
No, I feel the tension coming from the chat.
Oh,
They're like, get to the point.
sorry.
Okay. We can come back to that, though. The court finds that there is no substantial disparity of financial resources between the parties. The petitioner did not provide a financial affidavit, but testified she and her mother collectively earned $200,000 a year. The respondent filed a financial affidavit citing a monthly income of $12,000. For that reason, the petitioner finds the petitioner acted unreasonably in the litigation. So that is a finding of the court, that Laura Owens acted unreasonably in the litigation. Specifically, Laura Owens acted unreasonably when she initiated litigation without basis or merit, without an authentic ultrasound, sonogram, or physical examination, and in conjunction with the belief she passed tissue on July of 2023. The court finds the underlying petition premature at best. At worst, however, fraudulent.
Woo!
Fraudulent and made to incite communication, a relationship, or both with the respondent.
I love her words.
The court further finds that filing a motion seeking mediation for the purpose of telling the respondent that the pregnancies were not viable, disingenuous at best, but certainly misleading to the court. Still mislead the court. If the purpose of the motion was in fact to attend mediation, then the petitioner perjured herself today when she said the purpose of the mediation was to tell the respondent about the miscarriage. Either way, respondent likely incurred costs associated with the litigation prior to retaining counsel, and he is entitled to reimbursement of those costs. You lied? Wow. Shocked. The
Yes.
court also further finds that petitioner repeatedly failed to comply with Rule 49, even on order of this court. I believe that's the disclosure.
Mm-hmm.
Further compounded by the fact that on the day of trial, she testified that she anonymously sought care at Planned Parenthood in Los Angeles, which is not possible. While she failed to provide records of any Planned Parenthood appointment, anonymous or under an alias, respondent presumably sought records from all Mission Viejo Planned Parenthoods, as that is where, up until today, petitioner disclosed she sought care. This undoubtedly caused respondent to incur substantial legal fees attempting to locate records that may or may not exist in Los Angeles, but now appear to have never existed in Mission Viejo. Additionally, petitioner acknowledged she altered HCG test results, an ultrasound, and sonogram. Aren't they the same thing?
No.
I believe they're
The court-
two different things. I don't know what makes them different, but I think they are different.
Okay. I need to know that. The court further finds that the provisions of ARS 25-324B do apply because the petition was not filed in good faith. The petition was not grounded in fact or based on law. The petition was filed for an improper purpose, such as to harass the other party, to cause an unnecessary delay, or to increase the cost of litigation to the other party. Here, the court finds petitioner provided false testimony to the viability of the pregnancy in all three cases addressed in the procedural history. Additionally, prior to her deposition, petitioner sent a threatening letter to respondent indicating her intention to sue him for $1.4 million in collateral allegations unless he agreed to dismiss this action that she initiated. This judge
Mm-hmm. Going
The
for the
court-
fruit.
further finds Laura Owens. Oh, not even the petitioner. Let's call her out by name. Laura Owens knowingly presented a false claim, knowingly violated a court order compelling disclosure or discovery such that an award of attorney's fees and costs is appropriate under ARS 25-415. It is therefore ordered granting Clayton Echard's request for attorney's fees and costs associated with the family court law case. She does deny his attorney's fee request for the order of protection and the
Injunction against harassment.
thank you.
Got you.
It's further ordered that Laura Owens shall pay Clayton Echard's reasonable attorney's fees and costs not later than July 8th, 2024. Oh, she better get on that.
I think
What is
it's
that?
that they have to
20
submit.
days?
They have to submit the total of the costs by July 8th, and she has to pay it by July 28th.
Okay.
No, they have to
That was the next
object to
sentence.
it. Yeah.
Sorry, that was the next sentence. Punctuation, it's important. Period. Not later than July 8th, 2024, respondent and counsel for respondent, Clayton Echard, shall submit all necessary and appropriate documentation to support an application for an award of attorney's fees and costs, including a China doll affidavit and a form of proposed order by no later than July 29th, 2024. Laura Owens shall file a written objection and a form of proposed order. I was going to do a stream on China doll. China doll is where it originated from, but it has to do with reasonable attorney's fees. If Clayton Echard's counsel fails to submit the documentation by July 8th, no fees or costs will be awarded. Tight deadline. The court shall determine the award and enter judgment upon review of the affidavit as well as any objections. But wait, there's more. It is further ordered granting the respondent's petition for non-paternity. Hold on. Just for Clayton.
Do we have
For
any
Clayton.
celebration music?
I mean, other than what
I
I
don't
just
have
did.
mine set up. I could probably, I don't know. I don't have it set up right now. I could if I, actually got my ass in gear and fixed things, but I just wanted to highlight it for Clayton,
Yes. Love it.
Let's read it again. It is further ordered granting Clayton Echard's petition for non-paternity.
He is not the father. Hallelujah.
I know, where's the cheers? Come on, Brad.
I'm trying to load up my soundboard, but I can't get new sounds going.
Okay. It is, everybody play that song in your head. Okay, now imagine people cheering in the background.
Woo!
I know. Where's Maury? I used to have that clip. I don't know if I still do. It is further ordered.
With the where he imposed the one video.
Yes.
That's a long cheer.
We did it, folks. We did it. By we, I mean you. It is further ordered, the court having determined that Laura Owens has a pattern of similar, if not identical, behavior, and the court involvement referring this matter to the Maricopa County Attorney's Office for review of Laura Owens' actions pursuant to ARS 13-2702 and ARS 13-2809. I'll pull that up in a second. According to
Perjury
Maricopa
and
County,
tampering with that evidence.
perjury and tampering with evidence. According to the Maricopa County Attorney's Office, will be endorsed on this order.
Woo! Justice.
Yes. We are going to organize a letter writing campaign to the district attorney to drop the OOPs on the other two guys, like immediately.
Well, the
And
one
also-
on Mike can't be. It's not this district attorney. We would have to write to the one in San Francisco.
Okay, same thing.
Yeah.
We'll make him a video. San Fran's a little more hip, right? Maybe we can tag him in a TikTok. I don't have a TikTok. Can I borrow yours?
Nope.
I don't tick or talk.
No.
Oh my God, none of us are TikTok people on this.
Oh my God, we're old.
I have it, but it's not used. The only reason I created it is because my wife keeps sending me ones, and it kept telling you, "Hey, you should go download the app." It's like, fine, I'll do it, just because it's easier to look at it through the app than to look at it on a
We
webpage.
got Brad. I was going to say, does someone have a kid that has an account that we can borrow?
I hope you did it on a burner phone or something.
I wish I did.
I wish John was still in here because I would like to know if they are limited to only reviewing her for those two
No.
things, or is
That's
it just the
what's
start
being
of it?
recommended, but
Okay.
they should be
Yeah.
able to go after the not showing for the deposition and
Extortion, intimidation
Extortion.
of witnesses.
Yeah. It's
If she's
the web.
recommending it, it means she sees evidence to support a
Those-
charge of
at
it.
least those things. I see.
Yeah.
Yeah, that makes sense. I mean, if this isn't a textbook case for them to model and make an example out of, I don't know what is.
If
I mean,
they
I-
don't,
Yeah, I feel like
when there's somebody. Sorry, go ahead.
I was just going to say, I feel like people don't take perjury seriously anymore because they don't prosecute it. But this is a perfect case in order to make an example of. It's caught on camera on several different hearings with different judges, and even two on the same judge.
And abuse of the court system, and like you said, extortion and terrorism. I mean, for real.
Oh, also fake calls to police enforcement.
Yes.
Oh,
I mean,
abuse of 911.
911.
so many
Mhm.
fake calls to 911 came from that house and or casita.
Yeah. I mean, it's one
She
thing I
was calling
understand.
him from California.
I understand they, don't want to go after necessarily everybody who makes a false claim, but this is like one person doing it at so many different levels, and it really does need to be made an example out of.
Not,
And it's
not just
easy.
I
that.
think the fact
Example.
that this was a well-known case, she's done it multiple times, but that she specifically exploited the court
Yeah.
to hurt these people. Like she weaponized our justice system.
Yeah.
And I
she,
think
she writes
that's
an email. She doesn't get the response she wants. She calls 911 to report that. Like,
yes,
I've got a freedom
that
of
fact should be.
I've got a Freedom of Information Act request in for a police record where she submitted a zip file full of supposed alleged pregnancy proof examples before she filed the paternity action August 1st.
Oh yeah, and then she said, "Oh, the file's really big, so you may not want to open it, but I could tell you what's in there. So here's all my evidence."
I thought we had that.
she really is a narcissist, isn't she?
We probably do through various other things, but it'd be interesting just to see what she submitted to the police that she specifically wanted attached to a police record before filing the paternity suit.
I wonder if it's
Okay.
different than the stuff she submitted for the paternity suit.
Remind me to look because I might have that file already.
Well,
All right.
I paid $5 for it, so
Oh, if it's only $5, then who cares? So yes, like what Dingus did by calling 911 on Mike at the hearing. Like,
He should be sanctioned for that.
Oh
how
yes.
dirty and unethical can you get?
not
If he
just
doesn't lose his
sanctioned.
license
Peanut.
after this, who
He
should?
was subpoenaed. Okay. The court must decide on attorney's fees, but there's no reason to delay. Arizona Rules of Family Law Procedure that it is the final judgment and it shall be entered by the clerk. The time for appeal begins upon entry of this judgment by the clerk. And for more information on appeals, see Rule 8. And I believe they have 20 days. Is that correct?
30.
30? Okay. I knew it was 20 or 30. It is further ordered denying any affirmative relief sought before the date of this order that is not expressly granted above. Case closed.
Basically.
The fabulous Judge Mata.
Oh yes, honorable, fabulous, all the things. Queen Mata for the win.
Amazing Judge Mata. So, that be all, folks. So,
That's all, folks.
Clayton wins, like, almost everything. What she gets out of this, she leaves this with, she still has the order of protection against Clayton.
Yep. So he can't
Unfortunately.
still continue to disparage her online or whatnot.
Which he wasn't doing in the first place, but he can appeal it. She made it pretty clear what the situation is so that when he appeals it, it's like it should be easy, really.
You would
Yes.
think.
I agree.
I would hope.
Well, her basis, hopefully whoever hears the appeal, actually it would be great if it went back to duty.
He's
will
not
have
around.
the-
No.
Oh.
As a commissioner, he's not going to be on the appellate board, but it's going to have to go to an appellate judge who's most
I was
likely
thinking-
appointed.
It's every 4 years, right? Why does my camera keep freezing?
With the commissioners, it's different. I think.
Mm.
But
Thank
I
you,
think-
Deb. they'll have a record of the prior hearing. They'll see that the only issue was she was harassing him over being pregnant. Like she put into records all the ways that he was supposedly harassing her, and it was her telling him that he wasn't being supportive of her pregnancy and
him saying, I hate you, which is fair in the situation. I mean, that's not even harassing. That's literally just making a statement of his feelings, identifying them, and telling her. It's not like I'm going to do something to you. It wasn't.
I would hate her too if she.
That's what
did
any
that.
victim would say to somebody.
Dude, I don't even know her, and I hate her, okay? Like,
I think Matt made it pretty clear that she just didn't think she could, but she would have. And I think she just thinks she didn't have the power.
I wonder if she would have had the power to declare Laura a vexatious litigant, because she clearly is.
I don't think under family law she could. If it was in a civil case, I think she could have.
Because what if someone had 3 kids, in the, what is this, 5 years now?
She has 0.
But there's no proof that went into those other cases.
Right.
But she could have gone to
If she
could have been in a legit family law case that many times.
Mm-hmm.
If she was doing this vexatiously in family court, that would be one thing. But the only way that they would be able to do it is if it was a true family or a true civil court action.
Oh, I see. Well,
and Mike's was in another county, another state.
I have a meeting to hop on, so I'm going to have to drop off. But this has been lovely. Thank you for the invite. And I hope everyone
Thank you guys for helping me.
Celebration Tuesday. Woo!
Whee!
Yeah, forget Taco Tuesday. We're having burritos.
It's Justice Tuesday.
Breadsticks.
Justice Tuesday. I like
Wacky hooked us up. We're having breadsticks.
All right. Bye, guys.
Bye.
Bye. Take care.
You too.
Thank you again. He told me how to say his name before, and it's not Wacky, but
I know it's not, and I've said it wrong every time.
No, I don't know.
I hate my hair. If you see me, I keep messing with it. I hate it.
Oh, 11 months?
11 months. Yay.
Oh, 15 months.
Showing me
like
up
day
there.
One. It's like day 1.
That's before my time, technically.
The drunk beater. Any final thoughts? Comments section?
I am eagerly refreshing the Medium blog to hopefully catch something coming down the pike, but as of yet we have nothing, and I'm also curious as whether Gingras is going to post something on his blog.
Yeah.
That is very true. We get caught up in the seeing her intentional actions, and we forget that this is rooted in mental health, and more than anything, she needs treatment. But hopefully, I mean, be real about it. She goes through a criminal case. She's not going to end up in jail. She's not going to end up with anything major.
Unless she pleads out, but as we were discussing on Megan's stream, there's a likelihood that she could have between 15 and 25 perjury counts alone from all of the false statements that she could have. And I think in Arizona they said it was between 1.5 to 15 years per count of perjury. So she could be facing heavy amounts of jail time that, unless she pleads out as a first
time offender.
Yeah, first time offender, then, but I think the amount of counts that would be brought against her, and then tampering with evidence, and the other things that weren't specifically mentioned in the ruling, she could be facing easily 30 counts of various classes of felonies, because it's a class 4 felony for perjury, it's a class 6 for tampering with evidence.
But they'd run those sentences concurrently.
Yeah.
So she'd have a year.
And she'd get probation. She'll whatever it is, it's going to be probation. I mean, just from somebody who watches hearings all day, it very, very rarely do we see real justice, right?
So what I was getting at with that is that the best we can hope for, well, some of us, others of you might hope for something different, but a lot of us, the best we can hope for is that as part of her plea deal, she is forced to get the mental health treatment that she needs to fix the underlying issues that are causing this to happen to begin with, and not just put on probation where all she has to do is check in or wear an ankle monitor for a year or two, because that is going to do absolutely nothing.
No, because she'll play along with that, right? Like that'll be her ultimate stage.
Then she's the ultimate victim.
Right. I'm complying. I'm doing everything I'm supposed to do. Like I report, I do this, I do that. No, there needs to be intensive therapy. I'm not disagreeing with that.
I think requiring therapy would be a good thing. And they can do that because it's part of the criminal procedure. They require her to get a mental health evaluation, psych eval, very common in criminal cases. And the results of that will show where it needs to go.
Man, I wish she was in Bexar County, Bear County, however you say it. I'd love to see.
Do you guys want to bring up Clayton's Instagram? He just posted something 11 minutes ago.
Yeah.
I'd love to see Judge Boyd take a hit at her.
Oh. Okay, hold on. Where's the button?
Button?
Like the stop, go forward button?
Usually it's...
Oh. At the way bottom?
I generally just click on it once, but to actually
But it's like pausing it. It's not starting it over from the beginning.
Yeah. At the
I don't Instagram.
The very, very bottom, of the image, you should see a little line moving, and you kind of have to click on it and pull it back for a second.
Wait, this is 6 hours ago.
No, not that one. There's a...
Yeah. I know, it was just right here.
Now, I was able to get it to open up in a window. Why can't I not?
I'm trying. Sorry, guys. Hold on.
Technical difficulties.
Yeah.
Fun fact, Clayton is the same age as my son.
Okay, the title of the post is Justice is Served. Just
Very, very good day, because I woke up to read a very thoughtful opinion from the court, and justice is finally being served. This has been very emotionally exhausting. I want to thank the Woodnick Law Team, my friends and family, and the community that sought the truth out from the very beginning. And to my brothers, Greg and Mike, they want me to extend their gratitude out to you all. They've absolutely felt the love and support, and we three could not be more grateful. To the journalists, some of who were threatened personally, who pushed through to share this unbelievable saga of Laura Michelle Owens faking pregnancies and medical records in order to force relationships. You are truth warriors, and I'm incredibly humbled. Thank you for ensuring that the truth prevails. This morning, the court officially referred Laura Michelle Owens to the county attorney for criminal prosecution. I, of course, will participate in that matter, but I will not lose sight of who I am. I've had my own struggles, and I am now committed to helping others. As a mental health advocate, it is my sincere wish that Laura turns over a new leaf and gets the help that she needs. As I've said from the start, I would be the first to embrace her for making positive change. I do ask that individuals please refrain from any commentary that could be misinterpreted as harmful. With that being said, the sun shines a little bit brighter today. Today is a very...
I believe him. I think he truly means that.
I do too.
I think so.
And I
So
didn't know who Clayton Echard was before all of this. I didn't.
No, I didn't either.
No idea. But
So his comment on there was, this morning the court filed a ruling in our favor to award us legal fees on the basis that Laura Michelle Owens fabricated an entire pregnancy claim. The court has also referred her to the county attorney for criminal prosecution. I ask that individuals please refrain from any commentary towards Laura that could be misinterpreted as harmful. My hope is that she is able to turn over a new leaf and begin to make positive changes in her life. It is never too late to do so.
true story. I have a soft spot for Mike. I really do. I don't know. His case got to me.
Really?
Okay. Go away then. Sorry, Meg. I'll shut up. Thanks for your insight.
I'm sure that the person who has been through hell and had their name dragged through the mud for the past year disagrees and feels like they should get that 27 seconds to say, hey, it's over, and take that sigh of relief. But
And to show the other side some grace.
You do you, boo. You do
Right.
you.
And to show the other side some grace. He actually showed grace in that.
And he also still has an order of protection against her, or from her against him, so he still has to watch what he says.
Yeah.
It wasn't supposed to help. There was nothing to help. It was
Oh, he already
saying,
won.
hey, thank you. Thank you to the people who supported me. And guess what? My nightmare is over. My nightmare is over. I would celebrate that shit. I'd be having a parade. I'd be throwing the biggest freaking party.
Well,
She's got nothing. She's got nothing.
Yeah, she's
Done.
already been. She's a
Done. Tapped
litigated
out.
perjurer, fabricating evidence. They're not going to come after him for anything else.
she spent every card in the deck.
Sorry, I got construction going on outside. I'm trying to do it. I got 2 minutes.
What's the temp in Florida today, Meg? Because in
Actually,
Michigan, it's obnoxious.
3:30. Hold on 1 second. I'll tell you. It is 90 minutes to finish. So you can't go anywhere from here. Like the only thing she can do from here is fix herself, apologize, and try and improve. There's no more fight. Like, you lost. You can appeal it all you want, but you had nothing to stand on to begin with, and you've got nothing to stand on in appeal. Like, you literally had no evidence. You had nothing. You had nothing. You did not have a shred of evidence.
I really think that that's another reason why MATA didn't rule on the RO reversal. I think she didn't want to give them one window of opening for an appeal. I don't
Right,
think
but
the appeals court will even hear it.
Even if the matter.
No, I don't either. I think Mata found every
I think that even if she included a reversal of the order of protection, they could appeal that decision, but that wouldn't vacate the entire thing.
That's true.
They
You don't
would
want to
just
open
say
up
no.
any
This
possibilities, though, right?
right.
For a rogue duty. What if there's a duty?
There's no grounds for appeal.
What if there's a duty on the appeals court?
But there's
Right.
no grounds for appeal. What are you
No, I
going to
know.
appeal?
I know.
Like,
I'm
what could
saying
you possibly
That might have been
argue
the window.
against?
Yeah.
What?
I mean, I will certainly cover another dingus filing, regardless of how out there it is.
Right.
But it's going to be one of those things where there's no. She closed every door.
And even the
Unless-
things that
Pull something out your ass. That's
because you get thinking of the evidentiary hearing, of the things that he was most vehement against, didn't even get in. So I think that it's going to be. He says that he's disappointed in that there's a couple of things that he's concerned about, but until he files his notice for appeal and then actually goes forward with an appeal, then there's not really going to be much of anything to speculate on.
I think he's going to come home from vacation with a lot more on his plate than he anticipated.
Well,
all right,
once the-
guys. Sorry. You guys can keep going, but I got
No, we're good.
away. I've got a contractor that needs me outside.
Cool. Have fun.
Sorry. Everybody, thank
Bye.
you so much for hanging out,
Yeah.
reading this, going over it,
Exactly.
supporting justice.
Continued coverage in the matter of Owens v. Echard.
I'm soaking
She's
all
not
of it
done
in.
trying, but she's done getting anything. She can
Yeah.
come after us. She can harass people all she wants, but she can't hurt anybody because she has no legs to stand on.
Like and subscribe.
Yes, please. Probably got demonetized. All right, everybody. Have a wonderful one. I will talk to you soon. Take care.
Bye.